uh, the Employment Act 2007. And I'm basically trying to discuss with you the basic silent features of the Employment Act 2007. This act is the basic guidelines for human resource management, and therefore it is the basic tool that any human resource manager has to understand for him to be in a position to understand what is supposed to be done in employment, and therefore it is imperative that any person who is a practitioner in this field to understand the requirements of this act. So basically, the Employment Act 2007 is also known as the Chapter 2 to 6 of the Employment Laws of Kenya that was repealed in the former Employment Act, and the regulations of wages and conditions of employment act, also chapter 2 to 9 of the laws of Kenya. This act, whose commencement was in 2nd June of 2008, basically provides for general terms and conditions of employment in Kenya, and basically applies to both domestic and foreign contracts of employment. So therefore, it is important for us to know the following main features of this act. One, we have section 5 by 3 of this act that provides that no employer should discriminate directly or indirectly against an employee, all any prospective employee, or others an employee or a prospective employee on the ground of race, color, race, language, religion, political or learned opinion, nationality, ethnicity, social origin, disability, pregnancy, mental or HIV status, or in any respect of any recruitment, training, promotion, terms and conditions of employment, termination of employment, or any other matter that may arise out of employment. Uh, Further, subsection 4 thereof provides that an employer shall pay his employee equal remuneration for the work of equal value. So therefore, it should not pay some individuals fairly well than others while they are doing the same work of equal value. So it should be therefore noted that any employer who violates this provision may be prosecuted for criminal offense under subsection 5 thereof. Again, in section 6 of the Act, outlaws all forms of sexual harassment at the workplace and another place of work. So this provision is very stringent and requires every employer to take steps to ensure that no employee is subjected to sexual harassment of any form, and take disciplinary measures as deemed appropriate against any of these employees who subjects another employee to sexual harassment. Further, under section 2 thereof, an employee who employs an employer who employs 20 or more employees should be in consultation with the employees on their representatives if any issue of policy statement on sexual harassment, which should be brought to the attention of every person under the employer's direction. Also, it is imperative for us to note the requirements of Section 7 of the Employment Act that also provides that no person shall be employed under a contract of service except in accordance with the provisions of the Act. Section 8 goes ahead to provide that the provisions of the Employment Act apply to both oral and written contracts of employment. Under Section 9 of the Act, a contract of service for a period of a number of working days, which amount to an aggregate to the equivalent of 3 months or more, or which provides for the performance of any specific work which cannot reasonably be expected to be completed within a period or a number of working days, amounting in the aggregate to the equivalent of 3 months, must be in writing. So this must be noted by all of you listening. Then also, we have under the aforesaid section this obligation of the employer to have the contract of employment placed in accordance with the provisions of the law and ensure that the same is signed by the employee. Under Section 10, Part 1 of the Employment Act, a written contract of service is specified under Clause 9 above should be state the particulars of employment, which may, subject to Section 10, Part 3 of the Act, be given in installments and in any event not less than 2 months after the beginning of employment. Under subsection 2 of thereof, a contract of service shall contain the following particulars in details, and this must be contained in any contract of service. So for those who make contract of service and therefore we find some skeleton age, permanent address, and sex of the employee. Number 2, it should show the name of the employer. It should also show the job description of employment, date of commencement of the employment contract, form and duration of contract, the place of work, whether it's Mombasa, or Nairobi, or Kisumu, and the hours of work per day. It should also have to show the remuneration scale or the rate of employment and the method that used to calculate the remuneration and the details of any other benefits. It should also have the date at which employees' period of continuous employment began, taking into account any employment with the previous employer which accounts towards period and any other prescribed matter. It's important for us to note that Section 10, Part 5, where any of the matters I read above changes, the employer shall, in consultation with the employee, revise the contract to reflect such changes and notify the employee of the change in writing. Further, under Section 10, Part 6 of the Act, the employer shall be required to keep record of the employee, particularly for a period of about 5 years of termination of employment. So therefore, any HR is supposed to keep 5 records of employment for any specific employee for a minimum period of 5 years. If not contained in the contract of service, the employer shall also be required to prepare a statement containing the following particulars, which can be incorporated into the contract of service by reference. 1. Any term and conditions of employment relating to any of the following: A. Entitlement to annual leave, including public holidays and holiday pay. The capacity to work due to sickness, injury, including provisions of sick pay and pension schemes. The length of notice which an employee is obliged to have and entitled to receive to terminate his contract of employment. Then again, where employment is not intended to be for an indefinite period, the period for which it is expected to continue, or it is a fixed term, the date when it will end. So I want to repeat here so that we all understand that the following particulars which incorporated in the contract of service by reference must be shown. 1, that is A, any terms and conditions of employment relating to any of the following: A, entitlement to annual leave, incapacity to work due to sickness on injury and provisions pertaining to sick pay and then pension or pension scheme. Also, they should contain the rank of service in which an employee is obliged to give and entitled to have or to receive to terminate this contract of employment. Then lastly, we have where employment is not intended for an indefinite period, the period for which it is expected to continue, whether it is a fixed term and when it should end. And second, lastly, that the place of work must be shown, whether the employee is required permitted to work at the various places of work, and indication of that place of work and address of the employer. So that means you must be able to let your employee understand they may be working outstation, and that should be contained in the employment contract. And then also must have some disciplinary rules, and it's under section 13 of the Employment Act. It is after the material date there is a change in any of the particulars under section 10 and 12 of the Act. The employer shall give to the employer a written particular of changes at least 1 month after the changes. Then under section 16 of the Employment Act, where an employer does not give an employee a statement as required under section 10, read together with 12 and 13 above said, or an itemized pay statement required under section 20 of the Act, the employee may file a complaint with the labor officer or to the labor court. Also, let us note that under section 15 of the Employment Act, an employer shall display a statement in the prescribed form of the employee's rights under the Act in a conspicuous place which is accessible to all employees. Again, in under section 17 part 6 of the Act, if an employer advances to an employee a loan in excess of the amount of 1 month's wages, or in case of an employee with a written contract of 2 months' wages, the excess shall not be recoverable in a court of law. This section, therefore, implies that if an employer advances any loan to an employee, the employer shall be obliged to take separate security from the employee to secure the payments. Also, it is imperative for us to note that under section 20 of the Act, an employer shall be required to give every employee, except for casuals and or an employee engaged on this rate, okay. So, sorry for the distraction. Under section 20 of the Act, an employer shall be required to give every employee, except a casual employee or another employee, on a base rate or task rate terms of any period not exceeding 6 months, an itemized pay statement. That is a basic. That's not what the common language that we use, that most of you understand. Either at the end or before the time of payment of the salaries and wages. At the minimum, such statement should contain the following. So let us now understand. We should understand the net pay. Should understand his gross salary, and therefore this should be itemized. That it should be clear from the payroll or the payslip what is being deducted well enough. And then again, on the itemized statement of the payslip, an employer who is not incorporated or resident in Kenya may be required by the minister to pay a bond assessed at the equivalent of 1 month's wage of all the annual leave is 21 days minimum, with full pay after every 12 consecutive months of service. That is continuous employment. Where employment is terminated after the completion of 2 or more consecutive months of service, the employee is entitled to 1 3/4 days of leave with full pay in respect of each completed month of service, commonly known as pro rata leave. The Employment Act also requires that every employee shall be entitled to one day rest for every week of service. So that is Within a week, you are entitled to 1 day of rest as of duty. So this is understood and normally done. I don't think we have any problem with this requirement. Then we have section 30 that says after 2 consecutive months of service with the employer, um, an employee is entitled to sick leave of not less than 7 days with full pay, and thereafter 6 leave days, to sick leave of 7 days with half pay in each period of 12 months, 12 consecutive months of service, subject to the production of the employee's certificate of incapacitation, commonly known as sick sheet, work signed by the duly certified medical practitioner. And I would appreciate if we encourage our employees to be getting the certificate of incapacitation from the public hospitals, because I've seen in cases where uh, employees go to private doctors. I don't know if these are doctors, and they pay 200 shillings or 100, and they're given a fake certificate of incapacitation. And that certificate of incapacitation should be sent to the HR immediately, not after staying home for a period of 2 weeks. Then you come with the certificate and say, I was given, I was given, I was given, given the this certificate of service should be signed and given to send to the HR for purposes of manpower planning, and that should be done as appropriate. Under Section 29 of the Employment Act, women employees are entitled to 3 months maternity leave, and I've seen some employers discriminating women by giving them 2 months. So it's 3 months with full pay besides the normal annual leave I've said. So that means already can combine 3 months with 1 month, that becomes 4 months of annual leave now. 3 months maternity, 1 month annual leave, maybe 21 days in some most cases. So on the other hand, men employees are entitled to 2 weeks paternity leave. But even though we like following the requirements of the Employment Act, I normally see most men saying instead of 2 weeks, give me 1 week. But then the requirement is that they should be given 2 weeks to bond with the newborn baby. Then house allowance should also be given to the employee unless where a gross salary is stated to be inclusive of house allowance, normally commonly known as consolidated pay. So you have a contract whereby you are told you'll be paid consolidated pay, then it's not a requirement that it should be house allowance should be indicated. And normally I've seen to want to various courts of labor courts, and you find that somebody saying that this person was being paid a consolidated pay, and yet the pay slip does not show that this was a consolidated pay system. So make sure that this trick does not make you fall under certain issues with the labor courts. So under Section 34 of the Act, also, an employer under an obligation to provide medical treatment to his employees during the time of service, and even post for medical attendance during serious illness. So that is where WIPA now comes in, and we must make sure that you are registered. As I said, the provision by the employer should make a medical insurance scheme for the benefit of his employee. Further, under work injury benefits, that's WIPA, the employer is also obligated to pay compensation to an employee who has sustained personal injury or death as a result of accidents sustained either out or in the course of employment. So therefore, again, an employer can take out a workman's compensation insurance to meet such claims. So also under Section 42 of the Employment Act, probationary periods for new hiring or employee should not exceed 6 months. So probation should not exceed 6 months unless or otherwise. And therefore, if you are extending, you must communicate and you have to justify maybe this performance was never met. There should be continuous monitoring in terms of performance evaluation. Therefore, a probationary contract of employment can be terminated by 7 days written notice by either party. So any probationary period above 1 year is not probationary. It automatically turns itself to the uh, term employment. So also under Section 43 of the Employment Act, in any claims arising from termination of a contract of employment, the employer must prove reasons for termination of employment. Very clear. You have the burden of proof, the balance of probabilities. These are the terms you hear in court. Terms, balance of probability. The burden of proof now rests on the employer. You have to justify why it was necessary for you to terminate somebody's employment, while the government is looking for ways to engage people in employment. If the employer fails to do so, he shall be deemed to have terminated the employee unfairly. So if you cannot justify why the employee was terminated and the procedure of fairness was followed, that means documentation has to be done properly. The Employment Act also provides for quite elaborate dismissal, termination, redundancy, and complaint procedures in employment. Therefore, where an employer intends to terminate an employee, it will be advisable to approach a lawyer for detailed advice. All, if you are a seasoned practitioner in terms of human resource, you understand that an employee, after doing a misconduct, or suspected to have done a misconduct, that employee is supposed to be shown cause-wide disciplinary action should be taken against him or her. They write a statement. That statement is analyzed. That employee is given about not less than 7 days to prepare defense. That employee is brought into the hearing and sits and explain to a language that he or she understands, and advise that he or she can bring a witness of his own, so that if somebody does not understand English, it's explained in Swahili. And then the party who are the panelists are impartial and independent, that they have to analyze the cases as they come. They have been sensitized on employment law requirements, and then maybe you vote by majority and all that, how our bills are being done. So all these are the stringent requirements in terms of adjudication of terminations and how you communicate with the employee and their rights, observing their rights. So an employee is deemed to be innocent until proven guilty with these elaborate procedures. Under the Employment Act also, employees are required to keep and maintain records of their employees, including records of disciplinary actions taken against such employees, such as should be provided for the particular specified in Section 74 of the Act. So any normal misconduct will start with a verbal caution, I repeat, then first warning, second, third, and final, and then now maybe the issues of dismissal now comes in. Then you should also understand the difference between termination of contract and summary dismissal with dismissal. That where you justify that this employee, the relationship have been soiled, and therefore the issue of summary dismissal comes in. So you have to have the proper documents to justify this, and therefore in case of any litigation, you have to justify your decision. Under Section 76 of this Act, again, every employer who employs 25 or more employees is required to comply with the provisions of Part X of the Act. You go and check Part X. Under subsection 2 thereof, such employer must notify the Director of Employment of every vacancy occurring in his establishment or business or workplace in the prescribed form, that is Form X. And then also the employer is also required to notify the Director of every recruitment, abolition of posts, termination, layoffs of employees within 2 weeks from their taking effect. So if there are redundancies, you have to notify the Director within 2 weeks. Such an employer must also maintain a register of all the employees in every calendar year and send this to the Director not less than 31st January of the following year. So your returns must reach the Director by 31st of January every year. Also, it is the requirement of Chapter 8 Section 83 of the Act, that a foreign contract of service must be in a prescribed form and must be signed by both parties and attested by a labor officer. So, offer and acceptance must also be observed. Under Section 90 of the same Act, no civil action or proceedings based on arising out of the Act or contract of service is generally shall lie unless it's commenced within 3 years next after the Act. So, neglect or default complaint of any of the case of continued injury or damage within 12 months next after cessation thereof. Also under the Act, all labor and employment-related disputes shall be handled exclusively by the newly established Industrial Court, which is established under the Labor Institutions Act 2007. So these are the basic guidelines of the most stringent and salient features of the Employment Act 2007. And if you are an employer or maybe you are an HR practitioner who is new, I think it is very imperative that you download this act or you write in the comments section. Then I will send you the link to download, and then you will be able to make it your friend. Every day, make sure that you read your Employment Act as a Bible or as a Quran if you're a Muslim, so that every time you read each chapter, you make notes and understand. And when you are free, it is important that you go to the labor courts so that you see what are the cases that go on and how are issues being handled and what are the expectations of courts in terms of how the, the employment rules work. Also, make sure that you go to the internet and search for what we call there's this online case files. It is called case law, worldwide website, Kenya case law. You can be able to see how cases were brought, how they were educated, how they were they were handled, so that you equip yourself necessary knowledge you require as a HR practitioner. So I appreciate your time, and if there is any question, you can always reach out to me personally. Uh, my number is 0733744300. If you need any advice in terms of human resource or consultancy, you can reach out to me. I can always assist you. I've done human resource management for not less than 15 years. I've gone to courts more than 20 times. So when I talk, I'm very confident that I understand what I'm talking about. And if you are an employer listening to me, make your HR your friend. Don't think that because you have work, a child because has been employed by you know more than him. He knows more because he's the expert in the field. And the more you listen to him, it will save you millions of money lost through litigations and auctioneers coming to your premises to auction. So if he tells you this person should not be terminated, don't impose on him. Agile managers are trained to work independently, and they have a lot of office to make sure that any process they do is independent, is justifiable. If the government are followed, the duty of care now falls under you. So I have to make sure that the organization is safe, the directors are safe, the employees are safe, and everything is safe. So these are the things that we are supposed to make sure that there is a balance between. So the employees try to manipulate the organization by stealing, use terminate the employees. So if you see somebody trying to dodge here and there to deprive the government's dues, then we also don't work like that. So therefore we say the tenets of human resource, one is impartiality, independency, and integrity, and of course kindness above all. So in every endeavor we have to put God first, so that whatever we do, we pray God and He gives us the guidance we do. This job is not a very easy job. There's a lot of politics, and the various organizations that I've worked, many people think that they know the work of the human resource, not only the disapprobation. Somebody spends more than 4 years doing a degree in human resource management, and then you go about some 2 years to do the professional HR training for certification, and then maybe you go for masters. Then an employer comes and wants to manipulate you and say you are rusty, you are not very keen and all that, because maybe he or she wanted you to terminate somebody arbitrarily. And then when that person goes to court, when the court awards that person, then they also the same person will come back and say, why did you advise me? So the only advice is that HR manager, all HR will, don't follow instructions from their boss if you feel that they do not fall under the requirements, under the training and the practice of HR management. Please do not. Don't fall under their undue influence, normally practiced in various offices. Because of other engagements, we wish to thank you for listening to this online engagement, and we will always be coming from time to time, at least once a week, to educate you on various issues and trends in agile management, and of course, personal branding. So these are areas that I normally take very dear when it comes to how I manage whatever things I do. So sorry for taking your time, and thank you so much. Thank you so much. Now we end our live stream.